Hi, I'm DeGasperis. I'm a personal injury lawyer in upstate New York. In this video, we're going to talk about what happens if you get hurt at work. And remember, if you're hurt at work or due to someone's negligence, give me a call for a free consultation. If you get hurt at work, you should call a lawyer because you might qualify for a personal injury case. However, we need to distinguish who you might be able to go after. So you're never allowed to go after your employer if you're hurt on the job. Unless your employer doesn't carry workers' compensation insurance, that's an exception. But otherwise, you cannot sue your employer. But there could be what we call third-party action. Third party means someone outside of the contractual relationship. So your employer contracted with an insurance company to provide workers' compensation insurance coverage. That's a first party benefit because it's contractual. And it's great. Workers' comp is designed to cover you for your economic losses that emanate from an on-the-job injury. So you'll get covered for your medical bills, your mileage to and from medical appointments, and your wages. Terrific. But what if someone other than your employer was the cause of your injury? So say you're a UPS driver and you're driving on a highway and someone pulls out from a stop sign. Well, you were injured while working, so you get comp, but some third party caused your injury. Well, you can file a lawsuit against that third party to recover for your bodily injuries and your pain and suffering. And so you would get the benefit of workers' compensation insurance coverage and a third party lawsuit. Yeah, so if you're injured while working, that's how I measure it, while working, it doesn't matter where, you should call a personal injury lawyer. It's a free call. You'll get free advice. If the lawyer determines that there is no third-party case, then you'll probably be limited to the workers' compensation insurance benefits. And it is what it is at that point. And you may want to get a workers' compensation attorney who will represent you against the insurance company and in front of the workers' compensation board. But the personal injury attorney may determine that some other party was responsible for your accident. So again, if you are hurt while driving for work, you could sue a negligent driver. If you slipped and fell on someone's property while delivering for work, you can sue the negligent property owner. If you were injured while using a machine or a piece of equipment, you may qualify for a product liability case. And I've handled all of these scenarios, and it's really beneficial to the injured worker when they get both things, the workers' compensation insurance claim and the third-party personal injury case. That's how they maximize their recovery for their injuries and losses. Sure, anytime somebody feels well enough to work, despite the fact that they were injured or maybe they're still recovering from that injury, it's fine. It affects the quality of your case, but not necessarily in a bad way. I often tell people, if you go back to work, the insurance companies and juries, they're gonna respect you for trying to get back to work. But certainly you can do it, and I encourage people, if you feel well enough to work, even if part-time or limited duty, you should do that because one, it's a positive reflection upon you, and also you'll have some income coming in. And that's when people are most scared and vulnerable, is when they're injured on the job or injured off the job but unable to go back to work, and they're worried about their income. So typically if you work, you get paid, and that gives people some level of comfort. If you're hurt at work, I think you always want to report the accident to someone. You want to file a timely workers' compensation claim with your employer's workers' comp insurance company, and you want to call lawyers. You should have an advocate. Maybe you need more than one advocate. I always recommend that people call personal injury lawyers and workers' compensation attorneys. I think the first call always, though, should be to the personal injury lawyer, because the personal injury lawyer can size up whether or not you have a third-party claim. And if you do, then you should let the personal injury lawyer pick the workers' compensation attorney, because we want to be working together. The two lawyers should be working together to ensure the best outcome for the client between the two different claims. So yeah, the law allows for the workers' compensation insurance company to file a lien against your personal injury case. And listen, I don't like insurance companies, but it does make some sense. Why should the insurance company pay economic damages out on your behalf when some third party caused that harm or that damage? So what happens is the workers' compensation insurance company is paying out typically your medical benefits and your loss of wage benefit. Now, you would be allowed to file suit for those losses if you sustained them. But here you didn't sustain them, the insurance company did. So when you file your personal injury lawsuit, you will be financing and taking the lead for the recovery effort for both yourself and your own losses and the workers' comp insurance company's losses. At the end of the case, there will be a lien, and you have to use some portion of your settlement to pay that back. Now, that's not necessarily a bad thing, because sometimes we use the lien amount to drive up the value of your personal injury case, because now you have your personal injury, you have your pain and suffering, and all these economic losses. So oftentimes they can be used as a sword to make your case more valuable. And as the handling attorney, I'll take that lien into consideration because I want to make sure that I get the comp carrier paid back, and I want to make sure that my client gets everything that he or she deserves.